This week on The Record, the sheriff gets his day in court, but will he get to keep his job? We take you inside the courtroom in the trial of Alfred Montgomery. And the holidays are here. We check the record to see how you can change the course of a nation. Coming up right now. Welcome to The Record. I'm Mark Maxwell. Closing arguments are over in the trial of Alfred Montgomery. The first-year sheriff now waits only for a judge's ruling on whether he'll ever again lay claim to that badge voters pinned on his chest 1 year ago. Judge David Mason administered that oath of office to Montgomery when he was first sworn in. The same judge, acting as a lawyer now, defended Montgomery's right to keep that badge in court. And he's our guest now, the Honorable Judge David Mason. Good to have you with us in studio. We'll skip swearing you in on the record.
All right.
But we're glad to have you here.
Great to be here.
During your arguments defending Sheriff Montgomery, you leaned heavily on that notion of democracy, voters' rights, that removing an elected sheriff would have the effect of overturning an election where 91,000 city voters made their choice clear. But, as you know, there are no recall powers for a sheriff. There are for a mayor, there are for a Board of Aldermen president, a lot of different elected positions. Voters can recall them. The sheriff, they can't. So isn't the whole purpose of the quo warranto proceeding to protect the public when an official is accused of abusing power? And where is the line, in your view, between defending democracy and defending misconduct?
Well, first off, you're right in terms of the purpose of quo warranto. And that's important to think about, because it's used to replace the ability of the voters to recall. Now think about a recall election. Their ads, their speeches, the people are informed about all the details. Then they go to vote and they make a decision, because it's a big decision. Quo warranto is not like that. You have one judge who has this incredible power to remove somebody from office. That's why I consistently insisted that even though the quo warranto is the burden of proof is by preponderance of the evidence, it's a quo warranto and it is an extraordinary writ, and therefore all the evidence has to justify this incredible exercise of judicial authority that a judge has in the state of Missouri.
And from that front row seat, in the bench where the jury would normally sit, myself and other reporters got to sit and listen to your arguments, and you could tell, I think, most observers in the courtroom could tell that you were trying to lean the judge just in that 51% category where he was leaning in your client's favor. You pressed the court to believe that none of this rises to that high level of misconduct where, you know, in the presidential terms, high crimes and misdemeanors. But the record here includes recordings of the sheriff in his own voice discussing retaliation, his top commander describing chaotic financial controls in the sheriff's department, the sheriff in his own words on a 911 call saying that he, quote, detained a former deputy at a gas station, and of course that video that we've all seen of the Tammy Ross incident. I don't want to ask you to argue those cases right here, but I do want to ask you, in each of those instances, if you had been there, would you have advised your client to behave differently?
Well, you know, all of that depends on the circumstances. So take, for example, the thing about Mr. Wilson. If I was sitting in the office and the sheriff told me he had a call that somebody might actually be impersonating a deputy sheriff, and he said, I want to go check it out. And I said, well, that makes sense. Go check it out. Check it out before you call the police. Go see what the situation is before you call the police.
Or send someone else in your stead?
Well, either. It doesn't really matter either, but you need to check it out because this could be very, very serious. So he decides to go check it out, and he also calls the police, which are two actions that should occur. Now, in terms of detaining him there for a moment, there was no evidence that he actually wanted to leave. Remember,
that was the sheriff's word.
Yeah,
he used the word.
That's the word he used. But Mr. Wilson was in the store where he was working as a security officer.
You argued there was no detention.
He wasn't going to go anywhere.
You never put him in the back of a squad car.
Exactly, exactly. So there was no detaining. He used that word, but that actually isn't what actually happened.
I know a lot of reporters have asked you in press conferences and press gaggles about your role as both decision maker, advisor, legal defender, and as it pertains to this employment review committee. It came up a lot in this trial. I want to ask you about that. When did you, one of the witnesses testified, HR Director Michelle Patterson, that you were in charge of those employment review committee meetings. When did you form them first?
Well, I didn't form them. I followed the sheriff's direction. And I basically was I guess you can say like the chairperson to make sure that everything went orderly, that the employees involved
When
had
was the
plenty of
first one?
opportunity. As the first one, I can't remember the exact date. I know Ms. Saez was the first of them. I honestly cannot remember the exact date, however.
HR Director Michelle Pat, would you say, fair to say it was around the time of the federal indictment, generally? So,
It may have been after. It's hard for me to say, but I think it might have been after, but in that space.
so in all those months leading up to then, the sheriff, you've been advising the sheriff.
Correct.
All of a sudden, there's the creation of this Employment Review Committee.
Yes.
And Michelle Patterson testified on the stand that there have only been 2 Employment Review Committee hearings.
That is true.
With Tashana Saez and with Tyshawn Sykes.
I think I see where you're going. What triggered it? What triggered it was the federal judge saying these 7 or 8 people were basically that the sheriff could not talk with them. Now, when that list came out, contemporaneous with that, information started spreading about problems with Saez in particular, about how she was handling people.
She was ultimately fired.
Right. And because of the circumstances, the sheriff determined that the wisest thing to do would be to have employment review committees, because he knew he had the right to just fire at will. And, you know, look, you have employment review committees, you got to have people you respect.
If you were to act as a shield to protect the sheriff from any appearance of misconduct or retaliation, the way you've done it with this committee would be an effective way to shield him from that inference, would it not?
That would definitely be the way. And we are also hoping that the circuit court's personnel committee going forward will agree to provide an even extra layer of review.
So you think you're holding out hope he might get to keep his badge and his gun. I want to ask you, though, in closing arguments, you painted some vivid images, but then you stopped yourself short. You were protesting the images we've all seen on screen here of the sheriff in chains and the federal government's choice to, in your words, quote, march him around this courtroom like, and then you trailed off and stopped yourself. Do you want to finish that sentence? What kind of image were you trying to give the judge there?
I guess it was kind of obvious, but I'll tell you what I hear from a lot of black people in the community. They march him around like a runaway slave. And that hurts. It hurts a lot of people in this community.
It feels like the punishment or the image doesn't match the crime.
Yeah, it really, I've known people who really personally felt hurt by it and couldn't understand why somebody who had lived this life as clean as Alfred has and tried so hard to be raised differently than so many of the people who were around him, all of a sudden has been put through that. You know, and I've had to explain to people that's what the marshals do and that's how the process works. But the image is not good at all.
I hear you. Well, the story is not quite over yet, Your Honor. We are glad that you are able to come by. Judge David Mason, thanks for joining us.
You bet. Thank you for having me.
We're back in a moment. Welcome back. Joining us now is St. Louis Post-Dispatch courts reporter Katie Cull. Good to have you with us.
Thank you for having me.
You've covered a lot of different court cases here in the city of St. Louis, the paper of record, now appearing on the record. Glad to have you here. Put this in some perspective for us. Where does this case rank in its unique nature compared to ordinary court cases you might regularly cover?
Well, it's extraordinarily unique. I mean, this doesn't happen very often. You know, it's unusual that we've actually had 2 of these types of cases in the last few years. The one with Kim Gardner that never ended up going to trial or being adjudicated. And then this one, which we do get to see it all the way through the process. You know, I don't know of any reporter right now working that has covered one of these cases because they are so unique and so rare in the St. Louis area anyway.
Yeah, I don't know if it's fair to call a quo warranto, that weird Latin word, basically an impeachment trial, but it's essentially that with a one-man jury, the judge here. It was interesting in the closing arguments, we heard the state say it doesn't really matter if it's selective prosecution, if there's singling out or picking on the sheriff, even for a political motive, that he has to withstand the scrutiny to keep his job. What's the standard of evidence here in this case? We heard them say it was a preponderance of the evidence, but what is the actual hurdle that the state has to clear to actually expel him? And what does that mean for Alfred Montgomery?
Right. I mean, I'm not a lawyer, so I will give that disclaimer, but colloquially speaking, preponderance of the evidence is greater than 50%. So it's more than like probable cause, which is what's necessary to bring a criminal charge, but it's less than beyond a reasonable doubt, which is the standard in the criminal cases.
So if the judge is leaning 51-49 in favor of expelling on any one of the 6 counts, then he could, by that standard, expel Montgomery. I won't ask you to predict the outcome of the case, but reading Judge Omer, you've listened to a lot of different judges. At the earliest stages in this case, he was very, very slow to confuse the federal case with this one. Very reluctant to have any crossover. He wanted things clear-cut. He wanted evidence. How did you see Judge Omer's disposition or his questioning change or alter throughout this case, if at all?
I actually thought he remained pretty consistent. You know, there was some overlap in evidence between that criminal trial and this one, but I think he was definitely reluctant to kind of make a ruling on the criminal case, so to speak, and was very focused on the allegations at hand. And he really went pretty far to make sure that the lawyers stayed on track, to make sure that their witnesses were answering questions really tailored to, you know, what exactly they were trying to get at. And he even asked his own questions, as you saw, several times to get further clarification. Justin
Gelfand, one of the defense attorneys for Sheriff Montgomery, who's defending him in that federal criminal trial, left court on Tuesday and said, in federal criminal cases, we don't get to depose people. Here, the federal prosecutor was in court. He was putting some of those very same witnesses who would likely testify in the federal case on the stand. Was this a mini show trial or preview of what we might see in federal court in some ways?
I think in some ways, sure. I mean, as Justin said, I think that there's going to be some overlap in those witnesses. And if he were trying this case cold, so to speak, in federal court, he may have never heard what those witnesses had to say before they took the stand. And now he has a record of what they've said in court under oath that he can use to then impeach them potentially during a criminal trial. So that's going to be a really interesting dynamic that you don't see very often. And he mentioned that.
He also came very hard after the federal prosecutors earlier in the week. I think it was even last week when Justin said of the federal prosecutors, you don't just charge a case first and then go investigate it later. He came full guns blazing. What kind of a federal case, what kind of a showdown are you expecting in that federal trial to come?
I think it's going to be really interesting. You know, the federal authorities seem very confident in their case from what we've heard from hearings. You know, they have a lot of evidence. They have that phone call recording that was actually played during the Quo Warranto trial, in which Alfred Montgomery sort of makes threatening statements about people who are witnesses to the Quo Warranto and the federal investigation.
He calls them snakes. He thinks they're cooperating with the feds.
Yeah, it was really interesting. And so I think that it's going to be a fascinating case because you're going to get additional things based on from what we heard here. But I think yeah, it'll be an interesting case.
All right, Katie Cole, her maiden voyage on the record from the St. Louis Post-Dispatch. Thanks for joining us.
Yeah, thank you for having me.
We're back in just a moment. Welcome back. The oldest man-made structure in St. Louis, now back in the hands of the people who built it. Not a historic building or an old home. It's something you might even miss if you were to drive by. It's called Sugar Loaf Mound. The Osage Nation says the mound was built somewhere between 600 and 1200 AD, when its people lived here in Missouri. Not just the oldest structure in St. Louis, also the last of its kind around. Hundreds of other mounds just like Sugarloaf were built across the region, but since European settlers landed on this side of the Mississippi, all of them but Sugarloaf were leveled. A few homes were built on the site there, one demolished, another belonged to the fraternity Kappa Psi. On the one in the middle, it belonged to a woman named Joan Heckenberg. She lived there for more than 80 years before signing an agreement to transfer it over to the Osage Nation. The fraternity followed next. Now, the nation says it plans to demolish those houses, stabilize the mound, and develop an interpretive center there. In September, the St. Louis Board of Aldermen unanimously passed Resolution 109, recognizing the Osage Nation's preservation plan for the mound, and through it all, a local nonprofit helped to make that push to put the mound back in the hands of those who were here before. Civic exhibition group Counterpublic helped to facilitate it all. So now to talk about it, Counterpublic co-founder James McAnally. James, the Board of Aldermen recently recognized this area for its historic significance. Why does that matter to you, and what message do you think it sends the city?
Yeah, we were going through the historical records, and really we believe this is the first time the Board of Aldermen in the city of St. Louis itself has acknowledged the preservation of the mounds as important to the city's history. So again, understanding this significance of really connecting the city of St. Louis with the Osage Nation, which is a tribal nation based in Oklahoma now, but ancestrally connected here in St. Louis. So it's really kind of a landmark moment, a celebration from the Board of Aldermen, from Mayor Kara Spencer, of really reconnecting these histories, but also reconnecting a relationship here in the present.
I imagine due to lack of documentation, it might be hard to answer a question like this with very many specifics, but can you take us back in time, tell us a little bit of the history of the mound itself?
So many people know Cahokia mounds. This is a mound that is part of that larger grouping. So the Mississippian people were settled here, and it was a city the size of London at the time, the largest city in the Americas, really. And the mound groupings have a range of significance, but Sugarloaf Mound is what's known as a platform mound. It was also thought to be perhaps a signal mound. It's right on the river, so you could understand that you're entering Mississippian territory, you're entering the Cahokia region, but also it's thought to be visible all the way to Cahokia and Monk's Mound. So there's ceremonial significance. Certainly we don't know all the ways in which that is the case, but it's what's known as a platform mound, so it's kind of a stepped structure that was visible from the river, but also visible from many places around.
All right, take us from that time back then to the settlement of the city of St. Louis. What was that transition like with all the settlers coming in?
So in the settlement of St. Louis, first by the French and arriving to this area, the mounds were kind of appear throughout the historic record. There was an understanding. There were often debates about what their purpose were they natural formations or man-made. I think it's very clear to any kind of close look, unbiased viewer and historian at the time that these were man-made structures. The Mississippian people were not active at the time of European settlement, though, so it had already kind of splintered into many different tribes that were still in this area, including the Osage Nation that traces their lineage to the Mississippian people.
All right, and this recent recognition we saw at City Hall and in St. Louis, what does it mean modern day for the people of the Osage Nation?
And I think this is a kind of monumental shift. The Osage Nation, again, tribal government based in Pawhuska, Oklahoma, where the tribe was removed from Missouri and lands around it to the reservation there. But this kind of reconnection back to St. Louis is one step among many steps of kind of acknowledging the influence on the land here, the people and the place that we now occupy. It's, I think, really incumbent on us as residents of this land to honor and celebrate that, and also see what we can do to kind of celebrate their work here and acknowledge our own sort of presence on this land. But for the Osage, I think coming back and being celebrated by the Board of Aldermen, it really is a reconnection of a tribal government with our city government. And I think that is, the start of a much longer relationship, even beyond the kind of return of Sugarloaf Mound, but also, I hope, leads to many more collaborations in the future.
All right, thanks for joining us.
Thank you.
That full interview on the free 5 Plus app. And hey, when we think of Thanksgiving history, we often think of the Mayflower, Pilgrims, big feast, but don't forget that all-important day off work. One woman made that her decades-long mission to put the holiday on our calendar. We meet her when we come back. Are you still full? I know I am. Nothing beats that spread on the dinner table on Thanksgiving. The traditions of this holiday, they've been around in one way or another for centuries. But it was with the help of one president and an avid letter writer that it was cemented as an official American holiday. So let's check the record. It was July 1863. The Battle of Gettysburg claimed the lives of more than 50,000 American soldiers, the Union Army taking on heavy losses, but still ultimately prevailed against the Confederate soldiers. Just a few months later, October 3rd, President Lincoln would address the nation with the help of ghostwriter Secretary of State William Seward. Lincoln invited the country to set apart and observe the last Thursday of November as a day of Thanksgiving. Why? To heal the wounds of the nation and to restore it to its state of union. That was the first time a president had alluded to a national holiday of Thanksgiving. FDR would later make it official as the fourth Thursday every November, but none of it might have happened without the help of one woman, Sarah Hale. She would write essays and letters and ask others to do the same, calling for that national holiday. She made it a personal mission of hers for 36 years. She wrote Lincoln directly, eventually in 1863, asking him, "Use your power, create this holiday." Just weeks before the president gave that address, he got her letter, and he did it. So next time you think, I wonder if my politician knows how I feel, just write him a letter. You never know, you might just change the country's traditions. That's all of our show this time. Happy Thanksgiving. Until next time, we're off the record.